Let's rock on. So let me go ahead. It's not going to be one of my best ones, but let's back it up here. Rhonda asked a key question. She wanted to know, can you take notes in order to stay on track? And I want to give a shout out to my man Jonathan Ginsburg in here, who is also another attorney who does a lot of great Social Security videos. So please check him out because he does a lot of good stuff as well. All right. So when you get ready to go to a hearing, all right, a lot of times if you're going with the representative, they're going to ask you a series of questions before you go in. You might be a little worried that you might be forgetting. Now, if you got a rep, your reps usually are doing a fairly good job of preparing you for the kind of questions that they're asking you. And they're going to take detailed notes so that if you forget, they'll be there to refresh your memory. If you don't have a representative, or more importantly, you don't feel comfortable on your own, by all means, you can take notes with you. It's an informal hearing. It's not, nobody's going to meet you at the door and say, give me your paperwork, because you cannot take that in there. So by all means, if you feel that you need to have some type of cheat sheet handout or something to help you refresh your memory, by all means, don't hesitate to take that with you. So if you feel like that makes you feel comfortable, because you're already, trust me when I tell you, been doing this for a number of years. Jonathan can tell you this as well. He's been doing this for a number of years. Most people are not comfortable going into court. I just call it like it is. Most people are not comfortable going into court. That's not trying to be funny. That's not trying to be stank. That's just the nature of the beast. Most people do not feel comfortable going into court. So because they don't feel comfortable going into court, they tend to get a little nervous. They freak out. They freeze. They ramble. They do a lot of things. You want to go in there as comfortable as possible. So if you believe that taking some notes with you will help you out, by all means, take something with you. Let me get to Dennis's question. Dennis wants to know how long to get the filing fee waived. Okay. For those of you who are filing in federal court, there is something that's called a motion to proceed in forma pauperis, or an application to proceed without cost. That's in forma pauperis basically means in the form of a pauper. You're basically telling the court that you're too poor to afford the federal filing fee. Every court is a little different, probably runs somewhere in the neighborhood of $350 to $410, somewhere in that range and so forth. But what happens is that you file in court your complaint. You file what's called an application to proceed without cost, and then a motion to proceed IFP, usually an affidavit of indigency. And then what the court does is the court looks at all those finances and makes the determination of whether or not you have the financial ability to be able to pay the filing fee. Now, I tell people, when people ask me about how long it takes things in federal court, there is no timeline. They're not rushing to get those things back to you right away. Now, I will tell you this. It has been my experience that typically within about 30 days, that's an easy motion really, in terms, because you're basically, all they're doing is saying, can you afford it, can you not afford it? Now, here's something that you do need to be aware of. Every court is a little different in terms of how much time you have to file the filing fee if they determine you cannot get a waiver. So if they determine that you got to pay that filing fee, usually the court will say, you got to give me the filing fees within this particular period of time. So I want you to keep that in the back of your mind when you find yourself in a situation where you filed a motion to proceed IFP, and now you're sitting here going, oh my gosh, what happens if they're going to make me pay? Get your money together, start asking friends so that you know ahead of time if you need to take care of the filing fee. It's a pain. It's a pain. Let me just be blunt when I say this, because a lot of times they don't give you a standard by what they're looking for. So you're not going to get a cheat sheet from the federal court saying, hey, this is the threshold. And if you meet this threshold, we'll waive. If you don't meet this threshold, we'll waive. We won't waive. So I tell people a lot of times, fill it out and let the court make the determination. Now, here's one little thing that you need to be aware of. I don't know how every court operates. I know that when I'm filing for the IFP, there's two things that I do. I file the application to proceed without cost and the affidavit of indigency. They're two separate things. Some courts want you to do both. Some courts, one is fine, but I know the courts that I deal with, Middle District in Florida, the Middle District, Southern District, and the Northern District of Florida, it has been my experience, and even when I've done it in Tennessee, in the Middle District of Tennessee, I have experienced that typically they want the IFP and they want the application. Now you're saying to yourself, I don't know why you're saying IFP. The IFP, the in forma pauperis, is an affidavit. It's one you have to get notarized. The application is a little bit more detailed. Here's what I tell people to be mindful of. When you're completing those things are asking similar questions. Let me say this again. Those things are asking similar questions. So don't be slick and fill out information on one and then it'd be different on the other. So you want to make sure, let me say this again, you want to make sure that you take the opportunity to make sure that the information from both of those mirror each other, or you risk the possibility of either one, the court telling you to fill it out again, or two, the court making you explain why there's a difference, or three, them sitting here saying, you indicated information on one that shows you got resources, information on another one that shows you not. I'm going to go with the one that says no resource, that says resources, you got to pay the filing fee. So I always tell people, when you get these forms and you fill them out side by side so that the information is similar or identical, actually, because the reality is that you should be getting the same responses for both. So you're not doing anything slick, but you'd be surprised the number of times people will fill out one form, the affidavit, and swear on the oath that everything's right, and then file the application and then tweak it, and all of a sudden the two don't look the same. And all of a sudden the court, if the court can't make sense of it, they're not going to try to figure it out. They're going to make you clarify. And if you can't clarify to their understanding or to their appreciation, guess what? They're going to kick that thing back and you're going to end up paying the filing fee. And if you can't pay the filing fee, they're going to dismiss it. Plain and simple. Okay? So Dennis, I hope that answered your question. And Rhonda, I hope that answered your question as well, because I love the fact that she asked about doing things. And I want to take a moment to kind of, I know I started this discussion talking a little bit about politics, but for those of you who didn't hear because the mic was off, we can disregard that portion. I'll edit this out accordingly. When you're going to a hearing, let me just be blunt. Most people do not feel comfortable going to court. That's the real deal. Most people do not feel comfortable going to court. And that's not trying to be funny. It's just the nature, the nature of the beast. And so what ends up happening is, here you are for the first time, you're sitting before someone, you've been waiting a long time to go through the disability process. So that's step one. Two, you're finally there, your file is before this person who now is in a position of having to make a determination of whether or not they believe you're disabled. And so now you're freaking out because the moment of truth that you've been waiting for years. Most people, it's years by this point. They filed in 2015, it's now 2017. They filed in 2014, 2016. After 2 years of being denied, going to doctor's appointments, having your life turned upside down, you are now sitting in front of someone who is going to make the decision about whether you're disabled. And trust me when I tell you, you're going to have a brain fart. That's not trying to be nice. I'm not trying to be funny. I'm not trying to be a smarty pants. And Jonathan can chime in as well, because he's done just as many hearings as I have. Even the most well kept together person, even the most sophisticated. I've represented clients who've had less than a 5th grade education. I've represented clients with a PhD. And trust me when I tell you, when you're going into a court before someone who is tasked with the responsibility of determining whether or not you have provided a sufficient amount of evidence to demonstrate that you are disabled, trust, you will get nervous. The other part of the reason why you're getting nervous is because you really, despite the fact you're representative, and that's part of our responsibility, is to prepare you for the kind of questions that you're going to receive. The reality is that even when we ask you questions, even when we prepare you for the kind of questions you ask, I always tell people it's still kind of a crapshoot to know what the judge is going to ask you, because the judge could ask you everything that we said, or they could ask you stuff that was completely different. And guess what? If you're not prepared for that, you might have a moment. And so I always tell clients, part of the reason why you hire a rep is to save you from yourself. We go in there and we're listening. We're listening to see what the judge is asking, and we're listening to see what you say. Because trust me, when you're sitting there listening to the judge, it's hard for you to sit there and write down what they're saying and to kind of clarify. And maybe, can I get my understanding? That's why you have a rep. That rep is a go-between, because that's the person who's going to sit there and literally help you, save you from yourself, and clean up any funky spots. Okay? And let's be real here. And Jonathan hit it on the head right. You're sitting in a room, there's a judge, there's a reporter who's basically writing everything down. Don't worry about them. But if there's an expert in the room, that throws people, because an expert witness is there as a tool for the court. But that tool could be used to your advantage. It also could be used to your disadvantage. But if you're not quite sure what they're saying and what the dialogue is, because once they're done talking to you, it's a whole different conversation. You no longer are a part of the equation in terms of the ultimate conversation. They may come back to you, but that conversation now takes a major shift. We're now shifting towards talking to the judge and the expert about evidence that may be utilized to determine whether or not you are disabled. This expert is not there to testify about that they're saying that you are or you're not disabled. They're providing a response to various questions, whether it be a medical expert or a vocational expert. And sometimes when you're listening, that can take you to a whole nother loop. So keep that in the back of your mind. All right. Michelle asked the question. Let me come back here. If I'm approved for disability and my children are under the age of 18 or were for a portion of the back time I was deemed disabled, what steps do I need to do to take for getting those disability benefits? Very easily. Dial 1-800-772-1213. If you've been approved, tell them that you want to file an application for auxiliary benefits. And what happens is that, because going to the local office doesn't help you, because what happens is that you have to go through the toll-free number. And I only know this because I actually spoke to a assistant district manager who told me this. Whenever I have clients who get approved for disability and their kids are eligible to receive, I ask, can we send them down to you to do the auxiliary portion? She's like, no, because we actually require or rely on the appointments that are set up. So you call the 1-800 number. You tell them that you want to set an appointment for auxiliary benefits. The steps to get them are very easy. Typically, they only want to know a couple of things. One, they want a copy of the birth certificates. Fairly straightforward. And if that's the first thing. Second of all, where the children are staying is usually the other thing. And you'll say, well, why is that important? Well, if you're trying to get auxiliary benefits for your children and the kids don't live with you, the money technically is to follow the children, not necessarily you. So it's not one of those things where you're thinking, oh, okay, I get the disability benefits and I'll just farm this over to them when I get a chance. No, the money typically is to follow the kids. But if you have children in your care and you were found disabled, okay, and then you were determined to be eligible for auxiliary benefits for kids, contact the 1-800 number. Tell them that you want to have your application. You want to make an appointment for auxiliary benefits. Get the birth certificates together, and then this way, when you go in, you have all that information accordingly. Okay. Now, so let me go back to my original thing when we were talking about the hearing. People, there are a lot of great videos here on YouTube where different representatives have kind of shown you what to expect when you go to hearing. Here's the part of the ultimate problem that you run across anytime you have a disability hearing before a Social Security disability judge. The simple fact of the matter is that you don't really know what's going to happen until you go there. And every judge is a little different. There's some judges that are quiet. Let me back up a second. When I was in law school, they used to always tell us that there were 3 types of benches in appellate courts: cold bench, warm bench, hot bench. And you're saying, and in essence, that actually applies in Social Security hearings as well. And you're like, well, what do you mean by that? A cold bench is basically a judge who just sits there. Okay, just sits there. That means that they're not really actively engaging you. They're really letting you put on your case. They're not really asking questions. The pro of that is that it gives you the opportunity to provide the information that you need and put on your case accordingly. Downside is sometimes you don't know which way that court is going. So if the judge is sitting there really, really quiet, you don't know if they have a problem with anything until you see the decision. Hot bench is the exact opposite. You got a judge as soon as, they're doing all the questioning. If your attorney or your representative is asking you questions, then they're going to sit there and they're going to start jumping in and start interjecting and so forth like that. The great part about it is that it creates a dialogue, and in some instances, it lets the representatives know, and it lets you know which way they're going. However, it could be the exact opposite as well. You might just have a judge who's actively very engaging, but they really don't give you no idea which way they're going. So even though they're very proactive and they're asking these questions, you walk out there thinking you had a bad hearing because they were so aggressive and you win, or you're thinking you had a good hearing and you lose. Warm is a little bit of both. They ask some questions, but it's kind of, they let you do more of your own thing and so forth. In any event, the reality is that when you go before in court, you really won't know because your facts are unique to your fact and the judge is only handling your situation based on your fact. All right. Kyra, and please forgive me. I don't know if it's Kira or Kyra. I know I'm butchering it. Forgive me. Is it likely the judge has made his decision prior to seeing you? How significant is your file as opposed to your physical presence? Okay. Kyra has asked two questions, and I'm going to hit both. Is it likely that the judge has made his or her decision prior to seeing you? It's funny because attorneys will probably tell you that in some circumstances, the judge probably has it already in their mind which way they're leaning by the time you walk through the door. But let's be blunt when I say this. No one really knows. The judge is probably not going to tell you. Not like the judge says, I already made up my mind, so I don't know why you're here. So if a representative has gone before a judge a number of times, if a representative has gone before a judge a number of times, they can probably tell you their familiarity with that judge to kind of let you know which way they tend to go, depending on the circumstances. So it's funny because if you go into a hearing and the judge asks a very few questions and then you get approved, you're like, wow. More like the rep's probably going to say, yeah, the judge probably only needed a few things to address ahead of time. But that also happens the flip side. The judge asks one or two questions and then you go through this long hearing and the judge just sits there and you get denied. So the problem is, the reality is that using the phrase, is it likely? There's no way to know likely whether the judge has made or has not made their decision. You just don't know. Okay. Now, how significant is your file as opposed to your physical presence? Okay, let's pause on this for a second because somebody asked me this question, did you have to go to the hearing? When you file your request for hearing, you can actually ask people. You can ask the court to tell the court that you don't want to appear at the hearing, that you want them to make a decision on your file. Now, I'm going to tell you, most reps probably are going to tell you, are probably not going to want to do that. And you say, why? Because here's the problem with going that route. If there is an area in the file that the judge has a problem with, or if there's an area in the file that upon your review you think is a problem, you never get a chance to truly address it if you let the court just review it without you having the opportunity to respond. Does that make sense? And that's not trying to be funny. It's just me making it clear that a lot of times part of the nicest part, okay, part of the nicest part about having a hearing is that it affords you the ability to go before the court and provide clarifications on things in your case that's problematic. So your file, first of all, let me answer that question. Your file is always important. Let me make that point abundantly clear. At the end of the day, your file is always important. Plain and simple, end of the day. However, the reality is the nice part about your file. The nice part about your file is that if there's an area for you to develop, okay, if there's an area for you to develop, the hearing gives you the opportunity to address any discrepancies, any conflicts, any issues. It provides all that opportunity. But if you make the determination that you don't want to go to a hearing because you believe in your mind that your medical records are so strong that they should be able to approve them without you having to physically be there, you have the right to roll that dice. You do. You have a right to roll that dice. I can tell you, I was telling one of my clients the other day that because they were asking me about OTRs. And I said, when you're filing an OTR, what you're basically telling the court is that you believe there's a substantial amount of evidence to find in their favor. And on the flip side, there's no warts in your case. If there's a wart in your case, more than likely, you're probably not going to get up on the record. You're like, what do you mean by warts? Well, let's just say there's a period of time when you weren't getting treatment and it looks like you only went to the hospital and you've improved. Maybe there's an issue of drugs. Maybe there's an issue that you actually worked during that time. That's what I call warts. That, and there are other areas as well. But guess what? If you take it upon yourself to not go to the hearing, guess what? You don't get a chance to tell the court that, yes, you popped positive that one time, but despite the fact that you popped positive, guess what? You've been sober, and since you've been sober, your condition is not improved. You don't get a chance to tell people that you were working, but you were working for your uncle who hooked you up and gave you a job on the side and was just paying you on the books, but you weren't doing anything. You don't get the opportunity to tell the court that the reason why there's a gap in medical treatment is because you moved to an area, and as you were establishing care, by the time you established care, you had to move back to the same area, and then that's why you start again. When you choose to, and I tell people all the time, you have a right to do anything you want with your case. You bear the burden of proving, the regulation says you bear the burden of proving you're disabled. But here's the thing that I tell people all the time. If you choose to not, let me say this again, if you choose to not attend your hearing, move the ability to exercise your due process rights of addressing any particular issues and further supporting your case in a manner that is best for you. And that's not me trying to be funny. That's not me trying to make your situation look worse than it is. None of those things. It's my responsibility to tell you that as a representative, and I'm telling you, most representatives will say the same thing. As a representative, let me be the first to tell you that we bear the responsibility, okay, to present the case in the most positive light on your behalf, plain and simple. And if we believe you being at the hearing is in your best interest, we want you to be at the hearing because we want you to be able to address any problem areas that may be in your case. Now, Michelle, I have one other question. I got about 2 minutes left, so I can see if I can squeeze in maybe about one more question after hers. I'm down to a minute. Does it matter if there's income from my husband? Depends on the type of Social Security claim you have. If it's disability insurance benefits, the answer would probably be no. If it's SSI, the answer is probably going to be yes. But that's a question that you need to have specifically with Social Security because that's going to depend entirely on the circumstances of your case. Now, again, allow me the opportunity to articulate once more what I told you before. Once we're done here, okay? Once I'm done here, I'm actually going to modify the video a bit because the first portion of it, nobody could hear what I was saying. But I want to make sure a couple of things that you need to be aware of. One, because of the survey responses I get, I'm going to be moving to a weekly show. It's going to be recorded. I'm probably going to do only a couple of live shows, either one on request or maybe once or twice a month, depending on the circumstances. And I'm not going to have short 1 to 3 minute videos. They're going to be lengthy. It'll probably be anywhere between 3 to 5, depending on the question. So before I get out of here, let me hit these last couple of questions. First, DeAndre wants to know, if I stop working, will I be eligible? He said, I got SSDI, I get $706 a month. If I stop working, will I be eligible for SSI? And I don't understand that question because you're saying that means you're getting Social Security and you're working. That's a question you need to specifically ask Social Security. Virgo lady asks, can a person travel while on SSD? Sure. There's no reason. If you're now domestically, it shouldn't be a problem. If you go abroad to different countries and while you're still receiving disability benefits, you need to find out if it's okay to receive disability benefits while you're going to those countries. Certain countries, Social Security will not allow you to receive disability benefits while you're there. So make sure you clarify those things. As always, people, I look forward to seeing you. We're going to do at least one more live show before we switch to the new format. Starting next week, I'm going to be doing shows recorded on a weekly basis. I'll either post them like I used to do. I posted them on every Thursday. So it'll either be Tuesdays and Thursdays, whatever the case may be. But keep an eye out. They'll be more detailed. As always, keep being proactive in the community. Keep asking your questions. Keep chiming in and letting me know what I can do to provide a better quality. And that's what I love to do. I'm here to help. And as always, if you are looking for some assistance, by all means, shoot me a message, anthony.reeves@reevesfirm.com, and I'll be more than happy to holler at you and let you know if I can help out. Great day, everybody. Look forward to seeing you next time. Take care.